Thank you. Mr. Pearl, was there anything that you wanted to tell the court before I impose sentence today?
Yes, Your Honor. I got released from prison this last time and completed parole, paid off all my fines, had a truck, started a retirement fund, like was working, I had an amazing job and got introduced to this. And I tell you, it took my life away in 90 days. It took everything away from me in 90 days. Like that's how fast it took everything away from me. I literally, I didn't see it as drug like selling drugs. I just was like with friends, bringing it to my friends. Like I thought, you're drug using friends, and I was bringing it to them thinking I was helping them. And I remember my mom always telling me, like, the people who bring you drugs are not your friends. They're the worst kind of people. And I sat there this morning and last night thinking about that, and I'm like, I was the worst friend ever for giving people I care about that. Like it's probably the saddest feeling ever, knowing that I do care about some of the people that I literally, because I had money and a truck and transportation, I was offered, a chance to, when we found out my girlfriend was pregnant, like if you take this, when you go up, we could be going up to work every weekend, our power washing business, and they just offered me that and the money, and like, it's how fast it's spun out of control. It was one time, and then next thing I was doing it to support my habit, and it was drug users trading and selling to other drug users. It wasn't like, I'm not a drug dealer. I'm horrible. Obviously, I've done it twice and been caught. And every time, I'm not it's just sad because, like I said, I honestly, I just remember the words hitting my mom told me, like, people who bring you the drugs are the worst kind of people. They're not friends. They're not your anything. And I was doing it to people I care about. So when I got arrested, I told them everything down to the T, what I did, everything. I didn't lie by one single word. I told them every single detail of what I did, where I stopped everything, because I was just, it was just time for it to be over. It was, I made every single appointment with my CPS doctor, or sorry, CPS for our daughter. I passed every drug screen. I've been volunteering, going every week at urgent care, paying for it myself, taking drug tests, passed every single one. I've sent them to criminal corrections. I've been to AANA. It's been a hard month because my daughter's at the age now where she's finally can smile and laugh, like giggle and stuff. And I just wish I could have saw her before this happened, because I've never experienced anything like that, seeing her like that. I've never, experienced that kind of love or that scared feeling when you see a baby, like I was terrified if anything ever happened to her. And I understand everything I did wrong. Like I said, there's nothing that you could do to me today that I wouldn't agree with, because I know what I did was, I love Gaylord. I love Exeter County. I love it. I tell everyone how beautiful it is, and me bringing that stuff here is the biggest spit in the face. Me growing up here, I love this place. So I'm disgusted. So, I mean, if that tells you anything, I am sorry about it, and I'm here, I'm willing to take any consequences that come with that.
Thank you, Mr. Pearl. This case is unusual in so many different facets, in so many different ways. I'll start with the tremendous letters of support that I've read, probably from some of the people here in the courtroom, your brother-in-law, your fiance, your mother, all sorts of different people. Too many to count, honestly. Oftentimes I'll have a list and a specific number, but there were so many letters of support, and those speak extremely highly. Every one of them, they love you. Extremely highly, every one of them, they love you, which is significant. It's significant because oftentimes, in especially controlled substance-related cases, those who are in the active throes of addiction lose the support, trust, and love even of family members, because those family members get sick and tired of being sick and tired. And some of the words that you said today convinced me that maybe you're there now. You're sick and tired of being sick and tired. You're sick of this repetitive cycle that you've been in since the late 90s. Since you were a kid, you've been in front of this court, not me, other judges in different counties, in front of me, being sentenced and released, probation violated, parole violated. And it's been this cycle that is so self-destructive. And I say that it is self-destructive, but as you even acknowledge, it's also destructive to the community in general when you are the friend that's bringing drugs to other people. And that's how you categorize these deliveries. But your first delivery offense was all the way back in 2000. My guess is that was the same type of delivery that I'm looking at and dealing with in this case, which was you had marijuana, you shared it with other people or sold it to other people in order to support your ability to have that for free or less. I don't know the specific facts. Back in 2000, I wasn't even an attorney yet. But this is most often the types of delivery offenses I see. But you know, and the reason I bring that offense up, you know, dating back 26 years ago, that the law views delivery offenses the same whether or not it's that type of delivery where you're buying an ounce of marijuana to sell a quarter of that marijuana so that you can have free marijuana. It's the same under the law as a literal drug kingpin who sits on a yacht in the Caribbean selling pounds and pounds and pounds of cocaine or heroin or whatever the drug is. That's the only similarity. Then it comes down to the discretion of sentencing courts. Of course, my discretion is severely limited in some regards because the type of drug that you got invested in and started delivering, and even if I tend to adopt your statements that these were smaller sales, it's not your statements, it's in the PSI, you're selling a gram on one occasion. Even if I accept that, methamphetamine by statute and by legislative determination, which is outside of my control at all, has made methamphetamine one of the highest punishments in terms of any drug. And that's reflective of the dangerousness, the destructiveness of that drug. And it's evidenced by the destructive nature it had on you. Within a short period of time, any positive that you had done following release on parole was completely torn apart. And worse, these friends that you were delivering to, providing to, and otherwise supplying because you had the vehicle, the mode of transportation, and the money, even included your own fiance. She was sentenced before me for her role in this offense, included other individuals because, as the PSI indicates, you knew that you were under suspicion because you had been before. You're no stranger to the justice system, so you used another individual as a front person for you. She also got herself wrapped up in this justice system and was sentenced before Judge Mertz. In other words, while I understand that addiction drives poor choices, and that was a consistent theme of all of your letters of support, it also can't, and I don't think any one of them are specifically asking me to set aside any punishment because of that. The universal theme was they want me to see you as the person you are when you're not using it. And I do see that. I can see you here today. You don't appear to be under the influence of any substances. You appear to be clean, sober. I make the determination that you, in providing all of those details to police, I would expect, and I think it's probably accurate, at least my conclusion, that you're trying to purge and get all of these things over with. Because again, you're sick and tired of being sick and tired. That gives me hope that once you're done with whatever sentence I impose, you're not going to fall back into the old cycles. But the concern that I have is just as strong as my hope. The concern is evidenced by the fact that despite all of these support letters, and despite what I see as positive changes since these events, you've had a 44-year-old, 44-year life, or at least the 26 last years, you've accumulated a monstrosity of 24 felony convictions. Just convictions in 26 years. I have seen that before, but it's a rarity. And especially when I look at the number of charges that were involved here, I didn't count, like the prosecutor did, how many felony charges you faced. But that's absolutely astounding in a negative way. If you're not done now with being involved with controlled substances, providing them / delivering them to others, bringing them up into this community that you love, there isn't going to be anything to do in the future. There isn't much for me to do now. I certainly take into account positively your community standing, the fact that you have significant support, but I can't in good faith use those things as a way to justify anything other than an in the guidelines sentence. The guidelines are there for a reason. They don't control me. I could go under the guidelines and all I would have to do is explain why they're fair. But I also have to look in the mirror myself as a judge in this community and understand that when I issue a sentence for somebody who's being sentenced on their 19th, 20th, 21st, 22nd, 23rd, and 24th felonies at the young age of 44, that I have to say what you have echoed in your statement. Enough is enough. And if it's not, then the willingness of me to grant mercy in terms of understanding and accepting a lot of the things in these various letters that do help me offset the otherwise strong desire to look at the top of the guidelines higher, that is not going to be offset any longer. It's growing to the point, and I've probably even told you this before, it's growing to the point where when I'm sentencing on a 25th felony, if that ever comes to be, the letters of support stop having the echoes of truth to them. I will tell you that I was very much considering at the top end of the guidelines, consecutive sentencing between these offenses, all of those things, because without the benefit of your statements, your clear recognition of what is going on, your appearing to be sober now and taking this seriously, I am literally at my wit's end as a sentencing judge as what to do. And it's because of that, that despite the fact that there is good reason to consider consecutive sentencing, you were on felony bond when you committed some of these additional felonies, and I would back up a step and note this, these types of cases sometimes have effects outside of you. There is a significant push in the state of Michigan right now to have low pretrial release conditions, or in some states, none. These cases demonstrate, a multitude of them, why pretrial release needs to be carefully considered. And the unfortunate thing about your commission of these multitude of offenses is it makes judges like me want to ensure higher bonds at times in cases like this to protect not only the public, but to protect you from yourself. If you would have been sitting in jail on a very high cash bond on the initial case, you couldn't have committed many of the others. And that's unfortunate because that leads me to have a less sincere or positive view of people. But it's because I see cases like this, where you literally put yourself behind the bullseye and at significant risk of discretionary consecutive sentencing. So I understand why the prosecutor would cite the applicable statute and would ask me to consider consecutive sentencing, and oftentimes I would take him up on that suggestion. Again, the letters can't set aside the need for punishment in this case, but they do temper my reaction. And they do so because they appear to be written from good faith basis to bring forth what I need is context. And I also know that with 24 felonies on your record, at 44 years of age now and older by the time you get out, if you slip up when you get out, it's not as if it's not going to be brought into clear focus to the criminal justice system, law enforcement, and otherwise. In other words, they know you, you know them. As you stated, when you deliver, you're not very good at it. You get caught. And so I hope you continue to hold that close to the vest, because when you get out, if you make these decisions again, the hearings are going to be much shorter. The discretion is going to be much easier to exercise higher, and you're going to end up serving installment plan of life in prison. And I don't want that for you. I'm guessing you don't want that for you. I know you don't want that for you. So with all of those things said, I am convinced through your letters of support that there is still reason to hold rehabilitative goals as a possibility in this case. Again, contrasted against that is your long criminal history, significant high guidelines, and the need for punishment when you continue to make decisions that even you know you shouldn't be doing. And so I don't think the bottom end of the guidelines is appropriate, but it's my indication that I think my exercise of discretion is best used by sentencing you towards the low end of the guidelines, despite a massive ability of the court to upward depart if I wanted to. I also find that the strong nature of consecutive sentencing, when combined with the strong sentence that I'm going to impose in any event, is not necessary. In other words, I know I have the ability. I don't think that I need it, because this is either it for you, or you'll be back in front of me and I'll be able to correct the mistake I'm making today. It will be the court's sentence on the 6923 case where your guidelines minimum is 84 months, maximum 140 months. It will be the court's sentence of 96 months. That's 8 years minimum. That's significantly lower than the maximum that I could have sentenced you to without even exceeding the guidelines. 11 years and 8 months is the top end of that range. So the court sentences 96 months in the state prison system for that offense, up to 20 years maximum. You do have credit in 6923 for 60 days that you previously served. In file 6924 FH, the same sentence, 96 months minimum, 20 years maximum. In 6924, you also have 55 days of jail credit. On 6925, guidelines of 78 to 130, again, same sentence, 8 years minimum, that's 96 months minimum, 20 years maximum. In that case, you have credit for 53 days that you previously served. Thank you. Mr. Pearl, do you have any questions regarding the court's orders?
We are. Thank you.
Thank you, Sheriff's Department. Good luck once you're released.
Thank you.
Your Honor, I believe that is my morning docket.
All right, thank you.
Thank you.
Thank you. Good luck.